meritorious defense regarding the orders, that the increase was inappropriate. What was the reason for you not appearing on the hearing date? I know you mentioned it, but if you could be specific.
I was not notified. I was living in Florida. I never got notified. I mean, sir, that was about the 12th to 13th hearing already. I've been here so many times. I mean, how many times do I got to come here? And, sir, I brought the same evidence I've always had. No, I know. I'm not being rude.
No, let me be rude. I need it specific. You were living in Florida.
Correct.
And you had notified all the parties that you were living in Florida?
Yeah, they knew. They were mailing stuff to me, but I never received it.
And you claim you never received a copy of the petition seeking an upward modification?
Oh, well, no, I received that a long time ago, but I see, when I was living...
Oh, the hearing date.
Yeah, and the hearing, and here's my evidence and my support. I've never missed a hearing. And another thing, sir, on February 28th, 2013, I'm sorry, February 28th, 2013, I discovered there was a hearing I wasn't notified for. I showed up, but they wouldn't let me into, my ex-wife never showed up either. So technically she defaulted, and they wouldn't let me in. I had the evidence to show that. I had a lieutenant sign a piece of paper on February 28th, 2013. So.
The orders, just as a quick.
Yes, sir.
What's understanding is the B docket. Some of your motions and writs have been, the B docket was
Withdrawn. Well, she withdrew, if I remember correctly, my ex-wife and her attorney withdrew it.
So the only point that is.
It's an enforcement stipulation, technically.
The A docket is what everything will be done on.
That's the enforcement docket. The B document is the modification.
The B docket, we won't worry about the B docket.
Well, everything's on the A docket.
Right, that's what I'm saying. Yeah, so no, because some of your papers are on the B docket.
Yeah, no, I named them all because I never knew when they were existing, and sometimes it's like the original order Carr wrote was under B for a modification, but again, my ex-wife never provided any evidence, and now it's an enforcement. Here's my argument, sir. My argument is like the court has no jurisdiction for an enforcement based on the appellate court and the appeals court, that it should have been, my ex-wife should have filed it in the Supreme Court.
That one, my questions are a little more specific. So you were not given notice of the hearing, and at that hearing, that's the hearing you were found to be in default, and so the support magistrate rendered the decision based on the evidence at that hearing and increased the support payments, correct?
Yes, but again, she never provided me any evidence. Her hearing, I mean, that's when I got it in the mail that I owed $40,000. I'm like, where the hell did this come from all this? Now I owe $40,000 in arrears on top of it? Because that $40,000 in arrears automatically added another $1,000 on top of my support. So I went from paying $24.50 to $36.75. I was just barely getting by with $24.50. I mean, and also, I'm on a fixed income. I mean, my wife doesn't work and I don't work. I'm disabled. Yes, sir.
On consideration
Thank you.
of everything you said, the court is issuing an order that will stay the enforcement of the modification that increased the support payment. Do you original order remains. That was in your divorce. Okay? The court is not,
No,
not authorized to vacate that.
No, I understand that.
You're not asking me to. The increase is stayed pending your application to vacate the default judgment, and it is stayed until the final resolution of the default, meaning whether it's granted or denied, until it comes back to another court for any ruling, whether it's this court or an appellate court, the stay is in effect.
Could you explain that better for me, sir? So in other words, are you saying that the increase from 697 to 1131 is stayed?
Is stayed. That is stayed. What will issue an order today, staying that increase pending your application to vacate the default. The court finds that based on the information provided, and the court does note that Mr. Wallman is here on his own, but motions were served on the other side. Okay, the court finds sufficient basis to issue the stay because the court finds a sufficient basis to give Mr. Wallman an opportunity to have to have his motion to vacate the default heard.
Sir, may I ask you a question?
Yes, you may. You'll get a written decision. That's
Okay.
and this will be sent.
I need something, yeah, because
It'll be sent. You'll have a copy, and I don't know, did we send it to that computer?
Sir, could you put something on paper I need, because my, at the end of the month, my pension payment, they just sent me to today,
Let me stop.
the termination, but I think that they might get it again and start all over again.
You'll get a written decision today.
Okay.
Actually, before 1 o'clock. Before 1 o'clock, there will be a written decision saying, and I want you to be clear, I'm just staying. I'm not making any determinations. I'm staying the increase that was imposed from the default on the petition to modify the divorce judgment support payments.
So,
The original support, you'll still have to pay. During the stay, you still have to make whatever, what was it, 6?
yeah, but here's the thing, I understand what you're saying, but if you're going to stay that, I should have a credit. I mean, I have the numbers here, I overpaid by $66,000, so
Okay, a stay is just going forward. As far as an underlying, okay, we need the other determinations. You need a determination whether or not there's jurisdiction. You need a determination whether or not, and assuming there's jurisdiction, even if there's jurisdiction, it could be that the increase is deemed to have been inappropriate, then you would get the credit.
I know you can't give me, I'm sorry to interrupt you, because I'm happy what you're doing. I know you can't give me legal advice. I should go to the appellate division then, correct, for this? That's what I should do, based on your stay. If I go, see, here's my problem. If I go to Supreme Court, I'm supposed to be filing a Supreme Court. They won't see me. They keep telling me to come back here.
No, your motion to vacate has to be done here.
Oh, okay.
For the support magistrate. And if and when, whatever the decision is.
Then I have to
whether
do
you
that.
win or whether it's denied, it can come here, or at that point, if it's granted, you will then reopen the hearing, and all the evidence that you have, all the, as you claim, lack of evidence that your ex has, would be at a hearing. So it was reopening everything to give you the opportunity. Then, okay, and that would just be for your wife, your ex's petition for the increase.
Yes.
As far as you getting a downward from the 660,
Yeah, from the 1131 to the 697.
well, the 697 is the original.
I'm happy paying the 697. I never had a problem with that.
Okay.
Because I always paid my support. It was just my ex-wife, for some reason, came here, what, I mean, this is all hearsay. This is me telling you this because she's not here to defend herself. But my daughter went away to college. I had a dollar for dollar credit. So they didn't want to listen to me. They had to send my daughter had to go to a $40,000 a year college. I'm like, okay, I'll pay my SUNY cap, but the money I pay for the room and board, in my agreement, I get a dollar for dollar credit. So as soon as my ex-wife got a check less that, she came running here using this court, and ever since then, we've been embroiled in this since then. And in her petition, she claimed her income decreased and expenses, like the standard thing, when the evidence proved it was otherwise.
Okay. So to unravel this, to set it right one way or the other, okay, this court finds that you should be given the opportunity an opportunity to seek to vacate.
By petition? By petition?
That would be, I would do order to show. Well.
Okay, I know, yeah.
It should be in order to show cause.
Okay,
I'm offering you this.
thank you.
If it's wrong, I'm not a practicing attorney.
No, but I know you were at one time. You didn't get here because you're not an attorney, but.
But what you need to do, the best method would be to utilize the order to show cause provisions. Get your motion, the order to show cause is a motion by
Yes.
the other name.
Yes.
Okay? Get that in front of the support magistrate as soon as possible. Then she'll set it down, or she'll render a decision, and whatever that decision is, at that point, I'm sorry to say this, you're allowed to put in another order to show cause to seek this court or another court's review of whatever decision is rendered.
Okay.
And I'm sure you'll do your homework regarding, I didn't notice, the vacating that order based on the hearing.
Okay.
And if I may suggest.
Yes, sir.
Keep it limited to what you
Brief.
see.
Yep.
Okay? Jurisdiction is not necessarily what is important in a motion to vacate. Okay?
The
It's a
evidence.
separate, two things, reason why you defaulted and a meritorious defense.
But sir, I understand. I just saying,
I'm not asking
okay,
you to-
all right, you're right.
I'm just suggesting.
Okay.
Okay, because if I may,
Yes, sir.
permit me this,
You're allowed. You're allowed.
you like to bring up everything, and sometimes everything